Imagine being pulled from your home in the dead of night, locked in a concrete cell, and held for years without ever seeing a courtroom, a judge, or a formal list of charges. The heavy steel door shuts, the lock turns, and you are entirely erased from the outside world, stripped of your voice and your freedom. This nightmare scenario is precisely what the legal doctrine of habeas corpus was designed to prevent. Please note that this historical and legal exploration is for educational purposes only and does not constitute formal legal counsel. Translated literally from Latin as, "you shall have the body," habeas corpus is a fundamental legal mechanism that allows individuals to challenge their unlawful detention. It is a strict procedural tool requiring the government to publicly justify why it has deprived someone of their liberty. The framers of the American government considered this protection so essential that they enshrined it directly within Article 1, Section 9 of the U.S. Constitution. Notably, they placed this guarantee in the section specifically limiting the powers of Congress, signaling its vital importance as a permanent barrier against legislative overreach and state-sponsored tyranny. Often referred to as the Great Writ, this powerful legal concept did not originate in the United States. It evolved over centuries of English common law, tracing its earliest spiritual and legal roots back to the Magna Carta in the year 1215. During that historic standoff, rebellious barons forced King John to sign the charter, establishing the radical, world-altering idea that no free man could be imprisoned except by the lawful judgment of his peers or by the established law of the land. In modern legal practice, when a judge issues a writ of habeas corpus, they are delivering a direct, non-negotiable command to a prison warden, a military commander, or any detaining authority. The state must physically bring the prisoner before the court and present verifiable, concrete evidence that there is a valid, lawful reason for holding that specific human being in custody. If the government cannot legally justify the incarceration to the satisfaction of the court, the judge has the absolute power to order the prisoner released immediately. This mechanism serves as the ultimate judicial check on executive power, ensuring that agents of the state cannot act as judge, jury, and jailer all at once in the shadows. But what happens when the survival of the nation itself is at stake? The theoretical boundaries of the Great Writ are severely tested when a country faces internal collapse, armed rebellion, or external invasion. This exact constitutional dilemma violently fractured the United States during the Civil War. In 1861, facing violent riots in Maryland and the imminent threat of Confederate saboteurs cutting off vital railway access to Washington, President Abraham Lincoln made a drastic executive decision. Without waiting to consult a recessed Congress, he authorized the military to initiate a sweeping suspension of the writ along critical train routes between Philadelphia and the capital. Suddenly, military authorities possessed the terrifying power to arrest suspected Confederate sympathizers and hold them indefinitely without trial or public hearing. The Constitution's suspension clause explicitly states that the privilege of the writ shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. However, the constitutional text does not clearly specify whether the President or Congress holds that unilateral power to suspend civil liberties. President Lincoln justified his extraordinary actions by arguing that the entire constitutional framework was at imminent risk of total destruction. He famously questioned the logic of strict constitutional adherence during a crisis, asking whether all the laws but one were to go unexecuted and the government itself go to pieces, lest that one law be violated. This fierce executive tension culminated in the landmark Supreme Court case known as Ex parte Milligan. In 1864, Lambden P. Milligan, an attorney and fierce Confederate sympathizer living in Indiana, was arrested by military authorities in a dawn raid. He was rapidly tried by a military commission, denied a civilian jury, and sentenced to hang for treason and conspiracy against the federal government. Indiana was not an active combat zone, and its civilian courts were fully operational and conducting regular business. Milligan's legal team filed an urgent petition for habeas corpus, arguing that the military had absolutely no jurisdiction to try a civilian citizen when regular civil courts were open, functioning, and entirely capable of handling treason charges. In 1866, the Supreme Court delivered a unanimous and thunderous decision in Milligan's favor, fundamentally altering the landscape of wartime jurisprudence. The justices ruled that martial law cannot exist where civilian courts are functioning, declaring emphatically that constitutional protections are not silently suspended during times of war or national crisis. The ruling drew a hard, uncompromising boundary around executive and military authority. It established a lasting legal precedent that the government cannot bypass the standard justice system simply because the nation is in a state of conflict, ensuring that the Great Writ survives even the darkest, most chaotic periods of domestic turmoil. Yet the boundaries of this fundamental right would face an entirely new paradigm in the 21st century. The global landscape shifted dramatically following the devastating terrorist attacks of September 11, 2001, ushering in an era of unconventional, borderless warfare against non-state actors. The United States initiated the global war on terror, leading to the capture of hundreds of suspected enemy combatants overseas in countries like Afghanistan, Pakistan, and beyond. Instead of bringing these foreign individuals to American soil for trial, the military transported them to a specialized, highly secure detention facility at Guantanamo Bay, Cuba. Because Guantanamo Bay was located on foreign soil leased indefinitely from Cuba, the federal government constructed a novel legal argument, claiming that the detainees were entirely outside the jurisdiction of the U.S. Constitution. The administration argued that these individuals were unlawful enemy combatants with absolutely no legal standing to file petitions in American civilian courts. This complex jurisdictional argument created an unprecedented legal black hole. Suspects were held for years without formal charges, subjected to intense, highly classified interrogations, and completely denied access to the standard judicial processes that would normally verify the legality of their detention under Article 1. Human rights advocates and constitutional scholars argued fiercely that denying the Great Writ to anyone held by the United States government fundamentally betrayed the core values of the American justice system. Permitting indefinite detention without judicial review threatened to erode the very democratic principles the nation claimed to be defending on the global stage. The defining constitutional showdown over this modern crisis arrived with the 2008 Supreme Court case Boumediene vs. Bush. Lakhdar Boumediene, an Algerian citizen captured in Bosnia under suspicion of plotting a terror attack, challenged his indefinite, uncharged confinement at the military naval base. The central legal question before the highest court was whether foreign nationals held by the United States at a military base overseas possessed the constitutional privilege to challenge their detention. The government argued that extending the writ to foreign combatants outside sovereign territory was legally unprecedented and practically dangerous to ongoing military operations. In a fiercely debated, narrow 5-4 decision, the Supreme Court ruled that the Guantanamo detainees did indeed have the fundamental right to seek habeas corpus in federal court. The court determined that because the United States exercised complete and exclusive jurisdiction and control over the naval base, the essential protections of the Constitution extended to the prisoners held within its fences. Justice Anthony Kennedy, writing for the majority, emphasized that the political branches of government do not have the power to switch the Constitution on or off at will based on geography or convenience. The ruling powerfully reaffirmed that the Great Writ serves as an indispensable mechanism for maintaining the separation of powers, even in the complex context of global counterterrorism. The dissenting justices issued a stark, urgent warning regarding severe national security implications. They argued that unelected civilian judges were improperly interfering with the military's ability to manage dangerous foreign combatants during wartime, potentially endangering American lives by forcing the military to divert critical resources to federal litigation. Despite the fierce political controversy, the Boumediene decision effectively dismantled the legal black hole that had surrounded the detention camp. It forced the federal government to justify its detentions before an impartial federal judge, leading to the eventual release or transfer of numerous detainees when the classified evidence against them proved insufficient, heavily flawed, or entirely unreliable. The long, turbulent journey from the bloody fields of the Civil War to the isolated cells of Guantanamo Bay reveals a constant, underlying tension in American jurisprudence. The delicate balance between protecting national security and preserving individual liberty is inherently fragile and requires constant, unwavering judicial vigilance to maintain. At its absolute core, this foundational legal mechanism does not determine a person's ultimate guilt or innocence regarding a crime. It simply demands strict, transparent accountability, ensuring that no agent of the state, regardless of their rank, office, or wartime mandate, can lock a human being away without answering to the rule of law. Without this essential procedural safeguard, all other civil liberties become incredibly vulnerable to the whims of those in power. Freedom of speech, freedom of assembly, and the fundamental right to a fair trial mean very little if the government can simply make a dissenting citizen disappear into a dark cell without a transparent legal explanation. The historical evolution of this doctrine across centuries proves a fundamental truth about governance. Power, left unchecked by the judiciary, naturally expands. By forcing the state to continually prove the strict legality of its actions, the courts maintain a vital, impenetrable barrier against authoritarianism and arbitrary rule. The legacy of the Great Writ continues to shape modern justice, civil rights debates, and the fundamental relationship between the citizen and the state. It stands as an enduring, unbreakable promise that arbitrary detention will always be met with the fierce, unwavering scrutiny of the courts.